Hello, everyone. This is Sarah AuMiller, and I'm an attorney with the law offices of Hoyt and Bryan. And I am going to spend the next hour or so presenting our workshop. Hold on one second, I just got a little message. But I'm going to be presenting Unlocking the Mystery, Guardian Advocacy and Special Needs Trusts. So this is the presentation that I was going to do in person at Family Cafe, but now we are going to be doing it, doing a recorded version that will be submitted so everyone can watch it online and at their leisure. So I'm sorry I don't get to see all of your beautiful faces this year, but hopefully this presentation will be helpful for you. The first part of the presentation deals with special needs trust and special needs planning. And then the second part deals with guardian advocacy and traditional guardianship. So we'll go ahead and get started. This is just a little bit about our office, and this is our team. So we are focused on our clients and developing relationships with our clients so that we help you identify your planning goals and help you accomplish those goals. And that really is our mission at Hoyt and Bryan. And we are a firm that has been around since 1999. We just celebrated our 20th anniversary. We have our main office in Oviedo, Florida, and then we also have a satellite office in Altamont Springs. Both of those cities are basically suburbs of Orlando. And we are the only law firm in Florida to have 2 board certified attorneys, both in wills, trusts, and estates and in elder law. All right, so let's talk about what is special needs planning. Well, special needs planning is estate and financial planning designed to provide for and protect a beneficiary with special needs while preserving entitlement to needs-based public benefits programs. So the key to what special needs planning is it is estate planning and financial planning that is geared or set up with the main goal being to make sure that any government benefits that the individual is receiving, so that would be typically SSI through Social Security and Medicaid. Those are both resource tested government benefits, meaning you can't have too much money and qualify for those benefits. So basically, special needs planning is taking that into consideration and making sure that any assets that are transferred to the individual with special needs are transferred and held in such a way that those assets don't disrupt any government benefits the individual might be receiving or might be entitled to in the future. So here's a list of common ways that families plan for special needs family members. Unfortunately, the first item on the list is what we see most commonly. Unfortunately, typically people tend not to plan. I understand there's lots of things that parents have to deal with, particularly if you are a parent of a child with special needs. So sometimes estate planning and special needs planning gets overshadowed. But if that does happen and there is no planning in place, it doesn't mean that there isn't a plan. It just means that we have to rely on the state's default plan. And typically that default plan requires that assets be transferred to beneficiaries in a way that would be disruptive to any government benefits that the beneficiary might be receiving. We also use guardianship as a means to special needs planning. We're going to talk about guardianship and guardian advocacy at the end of the presentation. We can also use powers of attorney to plan for individuals with special needs, but typically when we are signing a power of attorney, the individual has to understand what they are signing. So usually powers of attorney are used in special needs planning with individuals who are very high functioning. Disinheriting is something that we hear quite commonly, that parents have the idea that they know that one of their children, a child with special needs, can't have too much money and continue to receive government benefits. So their idea of estate planning is leave all of the assets to the typical child, and that typical child will use the money and help their sibling with special needs. And that plan can work, but it typically doesn't work. There's a lot of issues and uncertainty when we leave assets to someone with the idea that they're going to share those assets with a sibling. Another way to plan is gifts to third parties. So that's kind of what I was just talking about. We also have, you can also own assets jointly. We can have outright gifts. And then also in special needs planning, we typically use trusts, and there are several types of special needs trusts that we use for planning for individuals with special needs. And that's what I'm going to talk about for the next 10 to 15 minutes. So what are the advantages of special needs trusts? Well, first and foremost, any asset that is titled in the name of a properly drafted special needs trust will not count against the beneficiary in regards to considering the amount of assets that this person has when we are applying or have applied for SSI and or Medicaid. So Medicaid says we can't have more than $2,000 of countable assets and be eligible for Medicaid. But if we have a special needs trust and there is $100,000 in the special needs trust there for the benefit of the individual, and that individual applies for Medicaid, any dollars, so the $100,000 that is in the special needs trust doesn't count towards that $2,000 asset limit. So number one advantage of a special needs trust is any asset that is in the trust is not countable when it comes to qualifying for SSI and or Medicaid. Another benefit of a special needs trust is it provides continuing management when the family, particularly the parent, is no longer available. So the trust actually provides instructions as to how the trustee, the person who manages the trust, is to manage the assets of the trust. So the parents can put into place specific instructions about how they want the assets that they're leaving to their child with special needs. They can put those specific instructions in the special needs trust. A special needs trust allows for greater independence for the individual by maximizing private and public resources. So again, allowing us to protect and preserve just private assets, potentially assets that are inherited from parents or from other family members or friends. And those assets are in the trust, available to the individual, while still allowing them to be qualified for public resources like SSI and Medicaid. And improper planning, unfortunately, can lead to uncertain outcomes regarding a special needs, a person with special needs beneficiary to their future. So trust, to kind of flip that statement around, I think another advantage to a special needs trust is that it can help provide certainty in planning for the individual. So there are two categories of special needs trust. First, there is what we would refer to as a self-settled or first-party special needs trust. The second category is what's called or referred to as a third-party special needs trust. The major difference between these two types of trusts is whose money is going into the trust. So a self-settled or first-party special needs trust is funded with the individual's own money. So typically there are 3 parties to a trust. There is what's called the trust maker. So that's the person creating the trust. There is the trustee of the trust. So that's the person who manages the assets that are in the trust. And then there is the beneficiary of the trust. And the beneficiary is the person who benefits from the assets that are in the trust. So a self-settled trust is funded with the beneficiary's own money. So to give you an example of what that might be, let's say that we have a grandmother, and let's say this grandmother has a life insurance policy, and she wants to designate, she wants the life insurance policy to go to her grandson who has special needs. So we know that this person may at some point in their life be eligible for SSI or may need SSI and or Medicaid. So let's say this grandmother purchases this life insurance policy and designates her grandson as the beneficiary of the life insurance policy. Well, when grandma passes away, now grandson, the individual with special needs, is going to receive the proceeds outright from this life insurance policy. So now the life insurance policy proceeds are going to be in the name of grandson. Well, let's say this is a $100,000 life insurance policy. When grandson receives those proceeds from the life insurance policy, when he receives the payout, if he is on SSI and or Medicaid and can only have $2,000 of countable assets, now due to this inheritance of the proceeds from the life insurance policy, he has become ineligible for those benefits. So what we would need to do is create a first party special needs trust because now this $100,000 is his, it's in his name, in grandson's name. We could create a first party special needs trust and put grandson's money in the first party trust. It's first party money. And then he would continue to be eligible for those government benefits because remember, anything that's in a special needs trust is not countable when it comes to counting for the resource test for Medicaid and SSI. So that's a first party special needs trust. A third party special needs trust is funded with someone else's money. So not the beneficiary's money. So the money that has gone into the trust is there to benefit the beneficiary, but it wasn't the beneficiary's money. So to go back to my example of grandma with the life insurance policy, if grandma did kind of the proper thing, the preferable thing, she would purchase this life insurance policy, then she would create a third party special needs trust. And as opposed to designating grandson outright as the beneficiary of the life insurance policy, she would designate the trust, the third party special needs trust, as the beneficiary of the life insurance policy. So then that way, when she passes away, the money never actually becomes the money of grandson beneficiary. It goes straight into the trust and is there for his benefit, but is considered third party money, not first party money. It was grandma's money that went directly into the trust. There was never a time that that money went directly to the beneficiary's name outright. So that's the difference between the two categories of special needs trusts. The reason we care about that difference as to whose money is funding the trust is because a first party special needs trust is what's referred to as a payback trust, meaning that when the beneficiary of the trust, so when the individual with special needs passes away, if there's any money left over in the trust, and if that individual has received Medicaid benefits during their lifetime, whatever is left over in the trust goes to pay back Medicaid. It doesn't go to other family members. Where with a third party trust, we can have, let's say we have a family with 3 children, one of whom is an individual with special needs. We can put the money in the trust for the benefit of that individual with special needs with the third-party trust. And then when that person passes away, there can be instructions in the trust that whatever money is left over goes to the other siblings, or to whomever the person creating the trust wants to designate as the beneficiary of whatever assets are left over in the trust. So first-party trusts are payback trusts, third-party trusts are not. I typically, when I give this presentation, I often get the question, can you have both? And the answer is yes. There are situations where we get forced into a first-party special needs trust situation. Let's, again, go back to my example with grandmom and grandson. When she has the life insurance beneficiary designation directly to grandson, she passes away, family creates the first-party trust to put the insurance proceeds in the trust. But then family realizes there's a better way to do planning, so then they create a third-party special needs trust so that then parents can designate the third-party trust for their life insurance policy so that their assets don't go into a first-party payback trust, they go into a third-party trust. All right, so it depends on whose assets, this is what we just talked about, it depends on whose assets are going into the trust to determine what type of trust is being created. So if it's the beneficiary's own assets that are funding the trust, then that is a first-party special needs trust. If it's someone else's assets that would be going into the trust, then it's a third party. So there are several different types of first-party trusts. So remember, the first and third are just trust categories. Then under the first-party special needs trust category, there are basically 3 types of first-party special needs trusts. So the first-party trusts are also sometimes referred to as self-settled trusts. They, again, are created with the beneficiary's own assets. So whether those assets are from gifts, from inheritance, from some type of like a personal injury settlement or accidental receipt, those assets are, if they're the individual's own money, that's going to be creating a first-party trust. And as I've already mentioned, the first-party trust requires a payback at the beneficiary's death. So again, 3 types of first-party trust. There's what's referred to as a D4A trust, and this is because the D4A, D4B, D4C titles are how the trusts are created pursuant to the United States Code. So basically the law. So a D4A trust is a disability trust. This is what we would typically use as a first-party special needs trust for an individual with special needs who is under the age of 65. A D4B trust is also sometimes referred to as a qualified income trust, and those are typically used when we are doing planning for individuals who need to be in a nursing home receiving long-term care as part of their ICP, that's Institutional Care Program, Medicaid application. And then a D4C trust is, again, typically used in a long-term care planning situation. So for individuals with special needs, we're usually looking to a D4A when we're doing planning with first-party money. So when is it that we're going to need a first-party special needs trust? We will need a first-party special needs trust if there is a personal injury award to the individual with special needs, if that individual receives an outright inheritance or gift, so that goes back to my example of the grandmother and grandson, or if the individual starts accumulating assets of his or her own, then those assets, then if we're getting to a point where assets are being accumulated, like for instance, maybe the person's working and we're having a hard time spending the money so that the bank account stays under $2,000, then we might want to create a first party special needs trust. But more frequently, and I don't have a slide for this, I apologize, but currently we are now able to create or set up ABLE accounts. So usually an ABLE account is going to work a lot better if we're accumulating assets from a job. But that's a conversation that you would want to have with an elder law attorney to determine, you know, what type of planning is going to make the most sense based on the specific situation. All right, and then there are two different types of third-party special needs trusts. So basically, again, third-party special needs trust, just as a reminder, is a trust that's created with someone else's assets, someone's assets other than the beneficiary's own assets. And we can create what's called a testamentary or standby third-party trust, which means that that trust is embedded in the trust maker, so the parent or the grandparent's own estate planning. So the parent sets up his or her own revocable living trust or last will and testament, and then the instructions for the third-party special needs trust are part of that plan. Or we can set up a separate standalone third-party special needs trust, which means it's a trust that gets created and is signed and is in existence even while the parent is alive. The testamentary trust would be, the instructions are in the parent's planning, but technically the trust doesn't actually get set up until the parent passes away and their planning is executed or carried out, I guess I should say. So when to use a third-party special needs trust? When it's when someone else is establishing a trust for the benefit of another person. So whether it's a parent establishing a trust for a child, a grandparent for a grandchild, a child for a parent, or a grandparent for siblings. Basically, when it's someone else's money, we're going to be wanting to create a third-party trust and directing that other person's money into the third-party trust so that we don't trigger a payback situation. So when it comes to special needs trusts, another thing that we always have to think about is who is available to be the trustee of the trust. So again, the trustee of the trust is kind of the worker bee of the trust. The trustee is the person who manages the assets to the beneficiary of the trust. So typically, if we have a kind of the most common situation is if we're creating a third-party standalone special needs trust and we have parents who are creating the trust for the benefit of their child with special needs so that when they pass away, their assets can go to their child for the benefit of the child, but wouldn't disrupt any of the child's government benefits. If we're creating that trust now and it's a standalone trust, typically the parents are going to be the trustees. But what happens when the parents are deceased? And that's really when the trust becomes relevant. We need to think about who can serve as the trustee. So we can have family, so of siblings, aunts and uncles, friends, to serve as trustees. We can also have a professional fiduciary. So that would be like an attorney serving as the trustee or a CPA. We could have a trust company. So there are actually professional trust companies out there. I mentioned a CPA previously. We could have a social worker or care manager or some combination of the above. And you will see there's an asterisk that says family and friends aren't recommended to serve as trustees of special needs trusts. I would actually modify that to say that friends and family are okay to serve for third-party special needs trusts, but it usually is a good idea to have a professional act as a trustee of a first-party special needs trust because the administration rules are very complicated and very strict because of the payback requirement. So just something to think about. Trustees are a critical part of the special needs planning plan. And you can have a perfectly drafted, detailed estate plan that, if we don't have a good trustee, isn't going to work the way we want it to work. All right, now we're kind of going to make the switch from special needs trusts to guardianship. But basically, in the special needs planning arena, the age of 18 is kind of a line in the sand. Basically, sorry about this. Okay, we're back in business. For some reason, my screen went blank. But okay, so we will back up, and here we go. So time frames for planning. As I mentioned, the age of 18 when it comes to special needs planning is really a line in the sand from a legal aspect. So basically, from birth to the age of 18, parents have full legal authority to make decisions on behalf of their child. Further, when it comes to being eligible for government benefits like SSI and Medicaid, the parents' assets are going to be countable when it comes to calculating whether or not the person is financially eligible for those resource-tested government benefits. So if the parents have more than $2,000 of countable assets, then the individual is not going to be eligible for those benefits. But when the individual with special needs turns 18, that kind of flips around. So once the individual is 18, regardless of the person's capacity level or ability level, in the eyes of the law, that person is considered an adult and has full authority to make his or her own decisions when it comes to their person, so healthcare decisions, and their property. So even if we have somebody who is nonverbal and has a reduced intellectual capacity, the individual is, in the eyes of the law, seen to be an adult and has full authority to make their own decisions, and the parent loses that authority the minute the child turns 18. In the reverse, once that individual turns 18, the parent no longer has the legal obligation to provide food and shelter for their child. So even if the child is continuing to live in the parent's house, legally the parent isn't required to provide those things like they are up to the age of 18. So consequently, when the person turns 18, they would now be eligible for SSI and Medicaid on a financial level, unless the individual has more than $2,000 of countable assets, which typically is not the case. So it isn't unusual for me to meet with families, and the families say, oh, well, I applied for SSI for my child, but we were denied. And my follow-up question to that is, well, how old was your child when you applied? Because if the child was under the age of 18, yes, the parent, most likely they would have been denied because they don't qualify on a financial level. But the minute that person turns 18, you can file an application for SSI, and assuming that the person is financially eligible and is also medically eligible, meaning they are determined by the Social Security Administration to be disabled, then that person should be eligible for SSI. All right, so 18, again, a line in the sand. Parents no longer have the legal ability after the age of 18 to make decisions for their children, but at the same time, they no longer have a legal obligation to provide food and shelter. Consequently, the person becomes typically eligible for government benefits that are resource tested for the first time. So I'm sure many of you are, if you haven't heard this before, are a little bit maybe scared or upset, thinking that when your child turns 18, you're not going to have legal authority to make decisions on their behalf. While that is true, there is a process that is available so that you are able to reassume the decision-making ability for your now adult child. And this process is called guardianship. So there are many different types of guardianship, but just on a basic level, a guardianship is a legal relationship between a competent adult and a person who, because of incapacity, cannot take care of his or her own affairs, and this person is called the ward. So here is a definition for an incapacitated person. So an incapacitated person is someone who has been judicially determined, meaning that there is a court process that has taken place to determine the person can't make his or her own decisions. So as I mentioned, there are several types of guardianship here in Florida. There's guardianship of the person. So that means the guardian would have the legal authority to make decisions regarding the person, so like healthcare decisions. There's guardianship of the property. So that in a guardianship of the property, which I just established one the other day, in that case, the guardian only has legal authority to make decisions regarding the ward's property, not necessarily their person. Plenary guardianship is a total guardianship, so it's guardianship of the person and property. There are also guardianships for minor children. So legally speaking, anyone under the age of 18 is considered to be incapacitated, so that they don't have capacity on a legal, in a legal sense. So if we have an individual who, let's say, inherits a bunch of money and they're under the age of 18, they legally can't deal with those assets. So we have to establish a guardianship of a minor. We have ETGs, emergency temporary guardianships. That's when we need a guardianship, but we don't have time to go through the full guardianship process. We can establish a emergency temporary guardianship while we are going through the traditional guardianship process. And then lastly, and most importantly for this presentation, we have something called guardian advocacy. So before I talk about guardian advocacy, I want to kind of compare and contrast guardian advocacy with what I would call traditional guardianship. Sometimes I hear people say full guardianship, but it makes it sound like a traditional guardianship, because full guardianship makes it sound like that it's the best, and anything other than full guardianship would be less than. That's not the case. So traditional guardianship. Traditional guardianship is typically a legal process that is that we go through when we have an individual who is over the age of 18, who after the age of 18 has lost capacity. So typically we use traditional guardianship when we have, let's say, an elderly person who has dementia. They no longer are able to make their own decisions, and they don't have powers of attorney in place, and we need someone who has legal authority to act on their behalf. We go through the traditional guardianship process. So this was someone who at one point in their life had capacity, but has now lost capacity. And traditional guardianship requires the filing of 2 court petitions. So there's first the petition to determine incapacity. So basically what this involves is a 3-person medical panel being appointed by the court, and those medical professionals prepare separate independent reports based on evaluations of the individual to determine whether or not the person is competent and whether or not the guardianship is appropriate. So then once those reports are prepared, the judge uses that information to then determine or consider the petition for the appointment of guardian, which is designating who's actually going to serve as guardian. So the biggest thing with traditional guardianship is we have this requirement for the 3-person medical panel. And as you can imagine, that is time consuming, it can be expensive, and it just makes the process a little more involved. So there are 3 essential steps of any guardianship. There's basically the determination of mental incapacity, then there's the appointment of the guardian, and then as the guardianship goes on, the court typically requires, if there's property associated with the guardianship, that the guardian provides an accounting to the court at least on an annual basis. So again, here's a slide talking about the determination of mental incapacity. This is kind of how the court goes about determining someone to be mentally incapacitated. And then with guardian of the person, so again, that would be a limited guardianship. The guardian is appointed for the purpose of making decisions related to the day-to-day care of the ward, so to their person, and that would also include decisions regarding the individual's residence, education, social environment, and healthcare. So then guardian of the property is simply appointed to manage the ward's property. So basically, you know, bank accounts get titled into the guardianship. Sometimes we have real estate that becomes part of the guardianship, and then the guardian is in charge of managing those assets and also providing a report to the court on an annual basis. That's the accounting, describing how those assets are being used and managed. So who can be a guardian? Basically, any resident of Florida who's over the age of 18. A non-resident can be appointed, but only if they are related to the ward. But a person who has been convicted of a felony, even if it's a parent, cannot serve as a guardian. So traditional guardianship can be extremely expensive. Basically, traditional guardianship, if it is uncontested, meaning everyone in the family is kind of on board, typically once all is said and done, the family will be spending somewhere between $5,000 to $10,000 to establish the traditional guardianship. But for families who have children with special needs, the Florida legislature has put in place a special process, a special guardianship process that is essentially a summary form of the traditional guardianship process. And that process is called guardian advocacy. And this is something that is specific to Florida. And we have guardian advocacy, which is available only for individuals who have been diagnosed with a developmental disability. And the individual has to have been diagnosed with one of the statutorily defined developmental disabilities prior to their 18th birthday. And the statutorily defined developmental disabilities, for a long time, there were only 5 of them. And these are the 5. It's intellectual disability, cerebral palsy, autism, spina bifida, or Prader-Willi syndrome. There have since been 3 more statutorily defined disabilities. And I apologize, I should have listed them here. But one of which is Down syndrome. So now we have 8 statutorily defined developmental disabilities. But typically, if we have somebody who, you know, usually even when Down syndrome wasn't a qualifying disorder or syndrome, typically we were able to accomplish or qualify for guardian advocacy under the intellectual disability umbrella. So in order to qualify for guardian advocacy, again, the person has to have been diagnosed with one of those 8 developmental disabilities, and they must have been diagnosed prior to their 18th birthday. So for example, if we have an individual who is 21 and they're in a car accident and suffer a traumatic brain injury, which then leads to intellectual disability, meaning they have an IQ somewhere below 70, that person is not going to qualify for guardian advocacy if they now need a guardian, because their disability didn't manifest prior to their 18th birthday. And then also, to qualify for guardian advocacy, the disorder must constitute a substantial disability and be reasonably expected to continue indefinitely. So we don't think that this person is going to get better. So guardian advocacy, again, is basically a summary process of traditional guardianship. And when we do a guardian advocacy, the big benefit is that the court doesn't appoint the 3-person medical panel to evaluate the individual. So we're bypassing that part of the traditional guardianship. We simply have to file a medical record with the court showing that the person was in fact diagnosed with one of the statutorily defined developmental disabilities prior to their 18th birthday. So guardian advocacy, I tell my clients, if you qualify for guardian advocacy, you 100% want to do the guardian advocacy process versus the traditional guardianship process, because it's a much easier process, it's a cheaper process, and it kind of gets you to the same point without having to go through the full traditional guardianship process. Timing for guardian advocacy. You need to start thinking about guardian advocacy prior to your child turning 18. But technically, we don't really file for guardian advocacy until the individual has turned 18. Now, sometimes there's an exception to this, but typically the way the process works best is we wait until the individual's 18th birthday, and then we file the guardian advocacy. So if you have a child who is 17, who maybe is even 18, and you feel terribly because you haven't established guardian advocacy, please don't feel bad. That is not uncommon. Usually what I like to ask my clients to do is that we start working on getting all of the court paperwork prepared a month or two before the 18th birthday. That way we have it ready to go and we can file on or as close to the 18th birthday as possible. Another thing I want to mention is I know the guardian advocacy process, because it's a court process, can sound scary. I have a lot of parents say, feel like possibly they're not going to be awarded guardian advocacy. That's not what this process is. This is a process that requires specific steps, but as long as those steps are taken and met, you will establish guardian advocacy for your child. The court's not looking to not establish the guardian advocacy. It's just that we have to go through the hoops required by law to establish the guardian advocacy. So here is a slide just kind of comparing and contrasting traditional guardianship with guardian advocacy. As I mentioned, guardian advocacy is less complicated and less expensive than traditional guardianship. The examining committee is not required for guardian advocacy. We simply file medical records of the individual documenting the disability and the diagnosis prior to the 18th birthday. And further, there's no adjudication of incapacity with guardian advocacy. So the person isn't adjudicated incapacitated. Basically, we're just selecting certain rights, legal rights, that need to be delegated away from the individual to the guardian advocate. And in most cases, those are decisions like healthcare decisions and social decision-making. So again, some more compare and contrast. A guardian advocate may have the same powers, duties, and responsibilities as a traditional guardianship. So just because some traditional guardianship isn't somehow better than guardian advocacy. It's just different. It's used for a different circumstance. The costs for guardian advocacy are about half the cost of a traditional guardianship. So typically we charge a flat fee of $2,000 to file for guardian advocacy. And that's if you want to use an attorney to file for guardian advocacy. Another good thing about guardian advocacy is you, as the petitioner, the parent, the person requesting to be appointed guardian advocate, you don't have to have an attorney representing you. Although I do guardian advocacies all the time, and I tell every single one of my clients that, and typically, I would say 9 times out of 10, I have clients saying, okay, I understand, I don't have to have an attorney, but I would like an attorney to help me through it, help me through the process. And I kind of equate it to, I understand that I can file my own tax return, but I know that my CPA does a much better job. So guardian advocacy for property though, so most guardian advocacies are for person only because typically there is no property. But if there is property, so if the individual maybe had a personal injury settlement or did inherit some money, then in that instance, if there's property involved, you do have to hire an attorney to represent the petitioner for the guardian advocacy. For guardian advocacy, there are education and background requirements. So basically, when we establish guardian advocacy, part of the process is that the person petitioning to be appointed guardian advocate is fingerprinted, and then those fingerprints trigger a background check that ultimately gets reported to the court to confirm that the person is qualified to serve as guardian advocate. So that happens before the judge signs off on the order establishing the guardian advocacy. Once the order is signed and the court has established the guardian advocacy, after that happens, the guardian advocate then is required by the court to take a 8-hour class that is offered through Seniors First, and it is a class about guardianship. Unfortunately, the class covers guardian advocacy for only about 5 minutes. Most of the people who are in attendance in the class are traditional guardians, and the bulk of the class is about preparing and accounting. And if we have a guardian advocacy of the person only, there's no accounting required. So, that it's not really relevant for guardian advocacy of the person, but it's an interesting class and it is required. So if you're appointed guardian advocate, it's required that you engage in this 8-hour class. And then it used to be that the courts would waive the education requirement, and that typically is not the case anymore. If it's a new guardian advocacy, there is a requirement to take the class. Then also with the guardian advocacy, there is a annual filing requirement. So once the guardian advocacy is established, it is established, but then annually, the guardian advocate is required to file an annual plan. And for guardian advocacies, it's very straightforward. It's just basically a report to the court showing where the individual lives, kind of what activities they're involved in. So basically, annually, there is kind of a check-in with the court, and that's what the annual plan is. These annual plans are required until the ward is deceased, or if the ward moves, then we will have to transfer the guardianship, and then the annual plan would be required to be, well, if it's in a different state, there may not be an annual plan requirement, or the annual plan would have to go to the court where the guardianship has been transferred. Another Another kind of consideration when we're doing planning, special needs planning is, and thinking about guardianship and guardian advocacy, is the involvement of, or the possibility of the individual signing powers of attorney. So basically, a power of attorney is a legal document where an adult gives another adult the ability to make decisions for them if they can't make those decisions themselves. So if we have an individual with special needs who turns 18, and let's say that that person is very high functioning and they can, you know, they have a general concept of what a legal instrument is and what their rights are, potentially we could have them sign a power of attorney where they are designating typically their parent to make financial, legal, and healthcare decisions for them. The issue with a power of attorney versus a guardian advocacy is powers of attorney can be revoked or changed at any time. So if your child designates you as their agent under power of attorney, and then they decide, they get mad with you and they don't want you to be their agent anymore, they can revoke that document and then do whatever they want. So consequently, a power of attorney does not provide protection from inexperience, poor judgment, or exploitation like the guardian advocacy does. All right, so here are some resources for special needs planning. Peggy Hoyt, who is the managing partner here at Hoyt and Bryan, she has written a book. It's called Special People, Special Planning, and that can actually be purchased on Amazon or on our office website. And this is her book. There's a few other good resources for your reference. And that is the end of the presentation. Typically, we have lots of questions. Unfortunately, I'm not able to field those questions right now. But if you do have any questions, please feel free to email me, and you can reach me at info@hoytbryan.com. All right. So thanks so much for listening to Unlocking the Mystery, Guardian Advocacy and Special Needs Trusts. And if anyone, again, has any questions, please feel free to get in contact with me. And I'm happy to talk about special needs trusts, about guardian advocacy, or anything else that you might have questions about. So thanks again, everybody. Stay safe and healthy, and hopefully I get to see you in person next year.